Case, which is Wolf versus Walker. Samuelson.
May it please the Court. I'm Timothy Samuelson for the Wisconsin defendants. There's two discrete points unique to Wisconsin that I'd like to discuss today. The first, as the Court's alluded to, is a positive negative rights argument. And the second is the remedies issued by the district court in this case. I'll address the second point first. The district court...
Why doesn't Wisconsin permit joint adoption by same-sex couples?
Respectfully, Your Honor, that's a question for the legislature. I don't have a specific answer.
You have no idea, okay.
I do know that...
Pardon, go ahead.
I do know that Wisconsin recognizes both couples in a same-sex relationship to petition the court to be recognized as a de facto parent. And there's a Supreme Court case...
What's a de facto parent?
Someone who would have the same or similar responsibilities and obligations as a parent. And there's a case from 1995, the Wisconsin Supreme Court, I believe, Holtzman versus Knott.
Does that open up the prospect of a child having three parents?
I don't know. I think what may trigger that circumstance involving three parents would be the presumption of paternity, and that's something that we've discussed in our papers.
I was thinking more of, for example, a child of an opposite-sex couple who divorce. One of the members then joins as a new partner of the same sex, who then is recognized as a de facto parent. You've got three parents. Right?
I don't know the answer to that, but based on the Holtzman case, the 95 Wisconsin Supreme Court case, the court discussed equity, recognizing that de facto parent. So there is the potential for that. I just can't answer that. That would be a question for the courts. Back to my discussion regarding the remedies issued by the court.
Let me get back to this de facto parent. So do all the rights and benefits accrue to that child when it's a de facto parent in terms of inheritance rights and all the other rights?
I don't know the answer to that question. And frankly, I haven't looked into that. However, those rights can be subject to contract rights. The parties can petition the court for those types of recognitions, but I can't say to Your Honor whether or not Holtzman stands for that principle.
Why are all those obstacles strewn in the path of these people? I don't get it.
That's a legislative decision.
You mean you can't think of any reason for it?
Well, the statute is written towards the general rule, not the exception. The general rule is for opposite-sex couples.
Why is that?
Because that's what the legislature has said.
Why? Does it have a reason, or does it need a reason, or what?
Well, I think there's several reasons. I think tradition is one of the reasons.
Well, how can tradition be a reason for anything? I don't get that. That's, again, the Loving case, right? The tradition of forbidding interracial marriage went back to colonial times. It was 200 years old by the time Loving came along.
Well, I think Loving was a deviation from the common law rather than codifying it.
What?
No. Where'd you come to? Look, interracial marriage had been forbidden in the colonies and in many, many states, not just southern but western, for literally, more than 100 years. So why wasn't that a tradition?
It's distinguishable. It's a different tradition.
Of course it's a different tradition. So in other words, tradition per se is not a ground, for continuing. We've been doing a stupid thing for 100 years, 1,000 years. We'll keep doing it because it's tradition. You wouldn't make that argument.
But we're not making that
argument. Don't you
argument.
have to have some empirical or some practical or common sense basis for barring these marriages? I mean, what's the reason?
Well, that's...
Get anything out of your brief that sounded like a reason for doing this?
But our position is tradition is based on experience. That's collective experience.
Yes, loving, tradition, hundreds of years, no interracial marriage. They can make the same arguments you would make. It's tradition. We don't want to change it because we don't know what will happen, right? Change a tradition. Terrible. What if men stopped shaking hands, right? Be the end of the nation, right? Right?
And see, I think loving throughout this positive-negative distinction of the 14th Amendment that you try to rest on, because, I just don't see how you get around loving, because I think that killed that argument you're making.
Well, loving is primarily an equal protection case to the extent it addresses.
It's an equal protection.
Sure, but it has the last paragraph
Right.
that is substantive due process all the way, right?
Right. In the
So
very
should
last
we
paragraph.
ignore that?
No, I'm not asking the court to ignore that. But what the Supreme Court's key marriage cases have not held that all of the rights and benefits incident to marriage are rolled into the fundamental right.
Mr. Samuelson, let me ask you about this positive rights argument, if I could. It's intriguing, and if I've got this straight, you're asking us to engage in a kind of interesting, startling thought experiment. You're asking us to contemplate a world in which a state might simply decide to repeal all of its marriage laws, and the federal Constitution would not forbid that, right?
That's correct.
I have to say, it reminds me of the responses of several states to Brown against Board of Education, who decided to abolish, in particular areas, public schools on the theory that they didn't have to. That ran into its own set of problems. But I still don't quite see how you deal with not only Loving, but also Zablocki and Turner, where the Supreme Court is telling us there's this fundamental right to marry.
Well, Zablocki, the context of Zablocki is significant. At the time, the only legal means for Mr. Redhale to engage in sexual intimacy was through the institution of marriage.
Right. So your theory then is that when Zablocki said, quote, "the right to marry is of fundamental importance for all individuals," close quote, the court didn't actually mean that, but just meant to say that there's a fundamental right to have sex with people without criminal sanction. Is that right?
No, what we're saying...
And are you saying that you think Zablocki should come out the other way today, now that criminal sanctions for sex outside marriage have fallen away?
No. I think the court would achieve the same result, albeit under a different analysis. First of all, in Zablocki, the court specifically made reference to the criminal fornication cohabitation statutes that were on the books in Wisconsin at the time. And so it was significant to the court's opinion, both in terms of substance and in context. But the holding in Zablocki conditioned the right to marry on a court order. And the two proffered bases for the state statute at the time was for counseling and collection. And the court held that the statute achieved neither. So Zablocki stands for the premise that under due process, the court may not condition marriage on a court order. And that's the significance of Zablocki. It doesn't confer the affirmative positive right to marriage and all its attendant benefits as a fundamental right.
How could it not have? I mean, otherwise, why couldn't you simply say, well, we're going to restrict this based on a court order?
But if Wisconsin were to get out of the marriage business altogether, would that be denying all of the citizens of the state a fundamental right? And I don't think it's just a trivial academic point. In Massachusetts and Vermont, the state courts stayed their mandate and allowed the legislature to consider what to do in response to the state court rulings that traditional marriage laws were not constitutional. Mm-hmm. That's what I would ask that this court does here.
Do you have anything besides tradition to argue for?
Sure. We've adopted
Indiana's. Yeah. What about this brief? You're familiar with this. This is in your case, the Family Equality Council amicus brief.
Not specifically. I have read it, but I can't quote from it, Your Honor.
I want to talk to you about this recognition of out-of-state same-sex marriages, because as I understand your position, you're saying Wisconsin's law doesn't void out-of-state same-sex marriages, it just doesn't recognize them. What are the practical differences between voiding out-of-state same-sex marriages and simply not recognizing them for same-sex couples living in Wisconsin.
Well,
I don't get that.
At the very least, the plaintiffs who were married out of state but reside in Wisconsin may still seek federal benefits, and in fact, in their discovery responses, asserted that they have filed joint tax returns. If Wisconsin purported to void and invalidate their marriages, perhaps they could not do so.
You could hardly void another state's marriage.
I agree, we can't, nor are we attempting to do that.
So, but aren't there other legal rights that they're not entitled to in Wisconsin?
Yes, but that may well be for other married couples. A person married in Indiana who moves to Wisconsin would not have the same bundle of rights in Wisconsin versus in Indiana. It's a trivial right, but one right that Wisconsin recognizes is the right to a marital joint fishing license. And as silly and trivial as that sounds, that was listed as one of the 73 harms by the plaintiffs in our case. Indiana does not recognize that right. Again, it is a trivial right. It saves a married couple $9 on a fishing license, so they save 25%, which is fantastic if you're a fisherman. However, if you move from Wisconsin and you go to Indiana, you do not have that right. Is that a denial of a fundamental right? It's our position that it's not, and that's because the fundamental right to marriage is for marriage only, not for the rights incident to marriage.
Now, you said tradition, and you're adopting Indiana's position. What else? Is that it?
Well, a deference to the democratic process. And one of the reasons that...
Well, that argument doesn't get you very far. You're really saying there shouldn't be any constitutional invalidation ever of a state or federal statute, because that's anti-democratic.
But we're not saying that...
Well, what would be an example of a statute passed by a democratically elected legislature that you would consider unconstitutional?
If Wisconsin passed a statute or a constitutional amendment forbidding interracial marriage, that would clearly be unconstitutional.
Why? It would be the democratic choice of the people of Wisconsin.
Well, at the very least, Loving says so. And Loving would trump the state.
But the whole question here is not whether democracy insulates. You argue that democracy insulates legislation from constitutional invalidation. Now, you have to have something better. You have to say, why is your law less... You accept Loving as governing precedent. Why isn't this rather similar, right? People want to get married, and you don't seem to have any reasons. You don't say homosexuality is a choice, right?
We're not making that argument. Frankly, we're agnostic. We just don't know.
What concrete factual arguments do you have against homosexuality?
Well, we have the Burkean argument that it's reasonable and rational to proceed slowly.
That's your tradition argument. It's feeble. Look, they could have trotted out Edmund Burke in the Loving case, right? What's the difference?
Frankly, Your Honor,
there was a tradition of not allowing blacks and whites and actually other interracial couples from marrying. Right? It was a tradition. It got swept aside. Why is this tradition better?
Well, the tradition is based on experience, and it's the tradition of Western culture.
What experience? Based on hate, isn't it?
No, not at all, Your Honor.
You don't think there's a history of rather savage discrimination against homosexuals in the United States and the rest of the world?
I won't disagree that historically homosexual persons have been the targets of discrimination. However, I won't agree that that's the basis for Wisconsin's laws.
Governmental discrimination, not just private.
Well, Wisconsin is the first state in the nation to prohibit discrimination in employment, in housing, based upon sexual orientation. It's been on the books for more than 30 years.
So why have you drawn the line at marriage?
Because that's a legislative decision. The policy of Wisconsin...
But then you're back to this notion legislative decisions are sacred, right? But every time a statute is invalidated, is unconstitutional, a democratic process is overridden. So give me a reason why for not that it's a legislative choice. What is the basis? What is the rational basis for a legislative choice denying same-sex marriage? We know that these people want to get married. We think, or at least I think, it's good for the kids. So what's the offsetting harm?
Well, respectfully, Your Honor, I think that flips the inquiry on its head. Rather than asking what the rational basis for the law are.
What is the offsetting? These people and their adopted children are harmed by your law. Now the question is, what is the offsetting benefit of your law? Who's being helped by it?
Your Honor, respectfully, that turns the analysis on its head. In
Look,
Johnson versus
answer
Robeson,
my question. Who is being helped by this law, if anyone?
I think society is, because it provides,
How is society being helped?
as Mr. Fisher discussed, marriage is an institution that provides for a...
I know, but how is it being... You're not trying to force homosexuals into heterosexual marriage.
No, we're not.
So what is the harm of allowing these people to marry? Does it hurt heterosexual marriage? Does it hurt children? What is the harm?
Frankly, at this point, we don't know if there's a harm, if any. This is what Justice Alito referred to in his Windsor dissent.
Well, what's that about? You're saying, and you could say it with loving. You could say, look, we're not given a good reason for banning interracial marriage, but it's been like 200 years, and we're afraid to overrule it because we don't know what'll happen, right? You could say that for every constitutional case. We don't know what'll happen. What, let women have access to contraception in Connecticut in 1964? We don't know what's going to happen. Society may collapse. Why isn't that always a problem?
First off, the yellow light's on. May I respond, Your Honor?
Yes, because the yellow light, it just tells you've got...
Right, it won't save you.
Anyway, I'm not going to interrupt you.
I said the yellow light won't save him.
It was worth a shot, wasn't it?
Yeah.
It's been tried before.
It has. Nobody's ever won that, though.
Respectfully, Your Honor, it's our position that when faced with rapidly transitioning social norms, a reasonable, prudent response is to act prudently, act slowly.
Well,
there are several different paths. Some states have said...
So you can't give us any rational, you can't give us the harm. Harm, of course, is tied into a rational basis, some basis for the government, some legitimate government interest has to be at stake, and you don't have any to give us.
I would say we defer to Mr. Fisher's arguments, but we also believe that marriage provides a mechanism for tying unplanned children to their biological parents.
Of course not. They give them up, right? There are these hundreds of thousands of people in foster care and so on.
Frankly, I reject that premise.
You don't think there are hundreds of thousands of children in foster care?
Oh, I don't doubt that.
Hundreds of thousands being brought up by same-sex couples?
Oh, I don't doubt that either.
Think it's harmful to them?
That, I don't have a position. I don't know. I'm not aware of any information or data or argument relating to it.
Really?
It certainly hasn't been briefed.
Samuelson, does Wisconsin law treat sexual orientation or the gender of parents as relevant to child custody decisions?
Frankly, Your Honor, I don't know.
Or to adoptions?
Well, with respect to adoption, homosexual persons may adopt, but the state does not recognize two-parent, non-married adoptions. Mm-hmm. So married persons may jointly adopt. Persons in a same-sex relationship, one may adopt, not the other.
An unmarried opposite-sex couple may not jointly adopt either.
Correct.
Right? Okay. So if the gender of the parents then is not relevant under state law for adoption purposes or for custody decisions, why is it relevant for the marriage definition, given the importance of the purposes that you have articulated and adopted?
Well, the policy bases are clearly set forth in Wisconsin statute 765.001 sub 2, describing marriage as a legal relationship.
But why the difference?
The definition is not a reason.
Mm-hmm. Well, the policy, it's not the definition, it's the policy.
What is it? I don't understand.
Respectfully, Your Honor, I don't follow the question.
Why you don't allow joint adoption by a homosexual couple?
I can't speak to that.
No reason. You don't have any sort of empirical or even conjectural basis for your law. Funny. Look, there's something odd. You have the same incest statute as Indiana about the first cousins. But the funny thing is, you say even if they're not 65, they just get a certificate from their doctor, right? Go to your doctor and say, I'd like to marry my first cousin. We're only 21, but we're sterile. So the doctor says, okay, sign. And that's fine for you guys. I don't get it. What's the purpose of that? It's so funny.
I can't speak to the purpose.
You don't like homosexual sex, and you don't like incest, except you're willing to tolerate incest.
I frankly don't have a response.
Nothing easier than getting a certificate from your doctor, right? Doctors like to please their patients. They come and say, we're sterile. Doctor signs a little slip, and they can get married. You have all these incestuous cousins running around Wisconsin. I don't get it. You don't worry about that. You don't worry about incest, but you're terribly worried about homosexual marriage. The future. What is it? Speculate for a moment. Suppose someone said to you, you're worried, should we permit homosexual marriage? The future, it's new, everything happening fast. What would you tell the person were the kind of bad things that might occur in the future that we should worry us? Just possibilities, right? What do you think it would be? The heterosexuals maybe turn into homosexuals?
We're certainly not suggesting that.
Okay. So what is it? You're not worried about that. That's good. So what are your other worries, right?
Well, what Justice Alito said is there's no consensus among experts, philosophers, etc. An example is no-fault divorce. After no-fault divorce laws were passed, divorce skyrocketed.
Look, with no-fault divorce, you could certainly say, look, were there problems here? No-fault divorce, marriage is going to be destabilized. You could speculate, right? So I'm asking you to speculate. What is it that we might want to? What would should slow us down because something bad might happen because of homosexual marriage in Wisconsin? Something bad in Wisconsin? What are the possibilities?
The possibilities are we don't know. There could be an unanticipated consequence.
Oh, there could be what?
An unanticipated consequence.
You can't guess?
The only example I can give is the no-fault divorce, and to the extent that had an adverse effect on the institution.
But we can see
That's fewer marriages, not more marriages, right?
I'm sorry, Your Honor?
That's fewer marriages, not more marriages.
Yes, but the argument there is that it had an adverse effect on the institution as a whole.
But that was discussed when no-fault divorce was being debated, obviously.
Right, and it was a policy decision.
Now, what are the concerns that bother people about the future of suppose 19 states have it. Suppose 50 states have it. What happens? What could happen?
Just like Justice Alito said, there's no consensus.
You have no idea what could. I'm not talking about consensus. I'm talking about what speculatively might happen that we should worry about.
The only example I can get is the no-fault divorce, and there might be a similar.
Okay, there might be similar.
Effect.
What would be similar? Give me an example of similar.
It would potentially devalue the institution of marriage and make fewer people likely to enter into it.
Why would fewer heterosexuals marry because homosexuals are marrying?
Your Honor, I haven't anticipated this. I'd be happy to brief it in supplemental briefing if the court would like.
You don't know anything about it.
Well, I don't know anything about it now. But respectfully, the only example I can give is the no-fault divorce.
Okay.
If I could just follow up a little bit, Mr. Samuelson, both you and Indiana have argued that what you really want to do is promote childbirths in marriage, right?
Correct.
and encourage parents to stick together and raise those children, right?
Correct.
I assume you're familiar with how that's been working out in practice over the last 25 or 30 years. I checked. From, let's see, over a 20-year period, 1990 to 2009, the proportion of births to unmarried mothers increased by 53% in Wisconsin, by 68% in Indiana. And obviously, with the Wisconsin figure was 37% non-marital births in 2009. If we break that down by age, race, ethnicity, and education levels, we find some groups of women who, under the current state policies, have more than 80%, some even more than 90% of their births outside marriage. It's a little hard to see if that's as important as you're telling us it is as a policy goal of the state. It's a little hard to see how significant it is with the rest of the state's family policies, given those results.
First of all, I am not aware of those results until just hearing them now. But
those are CDC. I mean, these are unimpeachable government statistics.
I'm not quarreling with the data, Your Honor. But
surely you're aware of the dramatic rise in births outside marriage.
I had not been specifically until just now. But my response to that, Your Honor, would be under Dandridge, the state may move incrementally. The state...
It's sort of like trying to focus on the mote in someone else's eye while ignoring the beam in one's own, in terms of if what you're really trying to do, as we're being told here, is define marriage strictly in terms of opposite-sex couples so as to channel births into marriage. It's a pretty unsuccessful policy.
Yet it's the policy of the state. And
you say we should move
incrementally. What it is a reverse-engineered theory to explain marriage in such a way that you avoid the logic of Lawrence and ignore a good deal of history about the institution of marriage and provide this very narrow artificial rationale for it.
I disagree with that, Your Honor. Since statehood, Wisconsin has held otherwise. Since Wisconsin Supreme Court decision from 1920 describing marriage as a relationship between one man and one woman with a nod towards procreation. That's the state's policy set forth in Chapter 765.
Let's see how that's responding to Judge Hamilton's point that this policy of trying to channel births into marriage isn't working.
That's the state's attempt. It's its goal, and its policy.
But it's failing. Why not try something else?
That's a question for the legislature.
Now, you say we should move, use the word incrementally. And in your brief, you said we should be getting information. What kind of programs does the Wisconsin government have to inform itself about how it might alter its marriage laws? Do you have an ongoing study?
I'm not aware of any specific ongoing studies.
Well, you say you're gathering information.
Well, Wisconsin does have domestic partnership, which was reaffirmed by the Wisconsin Supreme Court.
I'm asking you, what are you doing to gather information about homosexual marriage?
Well, as part of the domestic partnership program, there is a registration. And
is there a study effort going on?
Not that I'm aware of, Your Honor, but that's because I don't know one way or the other.
Okay, well, thank you very much, Samuelson. Mr. Essex?
May it please the Court. I'd like to go back to an issue that the Court raised during the Indiana argument, which is about whether there's a limiting principle to the fundamental right to marry, as plaintiffs in both cases have asserted it. And I'd like to suggest to the court that the limiting principle is found in the Lawrence case. Because the Lawrence court says that the liberty protected by the Due Process Clause protects personal decisions relating to marriage, procreation, child rearing, and a number of other interests. And says specifically that persons, quote, in a homosexual relationship have autonomy for those same purposes just as heterosexual persons do. And I'd submit that that means that at that point in the decision and the decision overall, the court is grappling with what is the scope of liberty protected by the Due Process Clause. That's precisely the question before this court about what the scope of the fundamental right to marry is.
Well, Wisconsin has just told us that it can repeal its marriage laws. Is there any reason it could not under the federal Constitution?
Well, Your Honor, I think that's an interesting question. I think, and obviously the court doesn't have to answer that here, but to respond to the question,
asking you.
Understood, Your Honor. I think it would be difficult for the court to be able to do that. I think that
politically it would be impossible, let's assume.
Yes,
but
I think that
it's a thought experiment here.
Yes,
so.
and following that thought experiment, I mean, just one way to sort of get a handle on that, I think, Your Honor, is to think the following. Assume that Wisconsin said, we're getting out of the business of marriage. We're going to have domestic partnerships for everybody. There's no doubt in my mind, Your Honor, that within hours there would be a lawsuit filed by heterosexual married couples or heterosexual couples that want to get married saying, no, Wisconsin, you can't do that to us.
And what would the answer be under the federal Constitution?
I think, Your Honor, the courts would say that there is a federal constitutional right to marry that means that the state must provide the name and the status of marriage.
With what? Okay, the name and the status. Okay, with what property rights, what inheritance rights, how many? Obviously, as Judge Crabb pointed out in her opinion, there's a long tradition in civilization of polygamous marriages, is coverture part of the federal constitutional definition of marriage that you would find?
To answer two parts to your question, Your Honor, I think in the question of what's covered by the fundamental right to marry, this is something that the California Supreme Court grappled with in the in-ray marriage cases, and I think they say, and I think the right answer is, it is the status of being married. It is not all the stuff that the state has attached to it. Because
what is the status then, if it's not the stuff attached to it?
I think that certainly, Your Honor, the status, I think, can be gleaned by the following. If Wisconsin or any other state offered domestic partnership to people who are married and said, hey, we're going to just trade the label, people who are married would say...
The label's insignificant.
Actually, Your Honor, I think the label...
What I'm driving at is that you've got a much stronger equal protection theory as long as Wisconsin recognizes the legal status of marriage and defines it as having various rights and obligations attached to it, you've got a respectable argument to the effect that gender doesn't matter, sexual orientation doesn't matter. But finding a federal right to marry that is undefined is a pretty problematic concept for substantive due process.
Well, Your Honor, I think that Your Honor is completely correct. The court could decide this case on equal protection. On due process, I think the limiting principle that the court is searching for, again, I think is in Lawrence, because the court says in defining the scope of liberty, you can't draw distinctions in terms of limiting that liberty based on homosexuality. And I think crucially here, in terms of the polygamy question, there is no Lawrence analog for polygamy. That is, there is no Supreme Court decision or decision of a court of appeals that says that limits on liberty can't be made based on the number of people who want to participate.
Do you think, this may sound a little far out, but do you think that the state can criminalize sex among more than two people right now?
No, Your Honor, I don't think it can.
So we don't need a Lawrence. Lawrence went far enough to make that point.
And in the context of marriage, Your Honor, there is nothing that says that limitations on marriage based on the number of people that want to engage in it is something that violates any principle of the Constitution, either in liberty or quite clearly under the Equal Protection Clause. But moving, Your Honor, you asked about equal protection. I'd like to turn to the argument for heightened scrutiny for sexual orientation classifications. And
I have to tell you, I don't get anything. I don't get any help from phrases like heightened scrutiny. what I find interesting is what are the harms of the challenge policy, and are there benefits?
And Your Honor, I think
If there are definite harms, which there seem to be from banning homosexual marriage, especially for the kids, then there have to be offsetting benefits in order to uphold the law. That's what I'm.
And Your Honor,
I don't know
I
if
think
you have any views on that. Obviously, Mr. Samuelson does not, so maybe you do.
Well, Your Honor, I agree with Your Honor that there are extensive harms that are imposed on same-sex couples who cannot marry, same-sex couples whose marriages exist in other states but are not respected by either Indiana or Wisconsin, and crucially the children of those marriages. One reason, Your Honor, that I think the heightened scrutiny question makes a difference here is that it controls a question about the presumption of constitutionality. If rational basis is the analysis that the court applies, and the only precedent on this issue in the Seventh Circuit at the moment is the Ben Shalom case that says that rational basis applies, then that carries with it a presumption that government discrimination based on sexual orientation is constitutional.
I mean, you've lost me. I don't. So presumptions are made to be rebutted. If they have good, if we know there are harms, if there are no benefits, then the state loses, right? Is there really more to it than that?
Well, certainly, Your Honor, under rational basis, even if the court applies rational basis review here.
I don't get it. Under anything, right? There are a lot of benefits. You can discriminate, right? Discriminate based of height. You can discriminate against basis of all sorts of things. Right?
Yeah, but Your Honor, the court has made clear that in a context where the classification that the state is using isn't relevant to government decision-making, isn't relevant to the ability of a person to contribute to society, and where that classification has been used historically to perpetuate discrimination both by the government and by private actors. Those are two criteria that should say to the court, look, this is not the kind of government action that should be presumed to be constitutional. Instead, we should ask the state to come forward as
well, if
Your Honor.
If they could show that there were tremendous benefits to children from banning same-sex marriage, then wouldn't that be possible? Wouldn't that be a respectable position?
Well, Your Honor, in fact, they can't, which I think is part of.
They could. Would you say no?
Certainly, Your Honor, in a hypothetical world in which there was demonstrable harm to, I suppose, heterosexual couples by allowing same-sex couples to marry and their children get the benefits, there would be especially the question of the level of scrutiny that this court applies would make a difference. And what I'd submit, Your Honor.
I'm sorry, you've lost me. Why does the level of scrutiny make a difference?
Because it goes to how the court evaluates the balance of harms.
I don't understand that. There are harms and there are benefits, and you weigh them in the balance. And if the harms exceed the benefits, it's unconstitutional. If benefits exceed the harms, constitutional.
I think, Your Honor, I agree with that analysis.
What else is there to?
Well, I think, Your Honor, rational basis review gives a lot of deference to the state. I think even under rational basis review, the Wisconsin's marriage law violates the Constitution because there is no rational connection between the classification that they actually drew and any government interest, including an interest in procreation. Wisconsin could have passed laws that might actually be rationally connected to their responsible procreation interest or their accidental procreation interest. For example, it could say to any heterosexual couple that is actually able to procreate that if you get married before you procreate, we'll give you a tax credit. That would be an incentive that's actually connected with the accidental procreation interest that they have asserted here. And a very different statute, because the statute that they're trying to defend here is a statute that draws a line based on sexual orientation and sex. It has nothing to do directly with procreation at all. And that's why there's no rational basis here. There's no rational connection between this classification and that purpose. The other interests that the state has asserted, tradition, the courts addressed, tradition is not something that can justify a history of discrimination, and it is not an independent interest that explains the classification that the state has drawn. Another interest raised by the state is go slow and do this cautiously. And they say, look, we're worried about consequences for the future. We don't know what they are. and submit to the court that that is the primary argument offered by the House of Representatives in defense of the Defense of Marriage Act in Windsor, an interest that was necessarily rejected by the court, as, by the way, were all of the other interests that have been asserted here by the state.
There seems to be some disagreement over whether Wisconsin's law denies same-sex couples that are already married legal benefits. Now, we know about the fishing license, but can you tell the court what legal privileges are being denied to same-sex couples whose marriages were performed in another state?
Yes, Your Honor. They are denied the hundreds of rights that the state provides to married couples under Wisconsin law. So the state, based on the Constitutional Marriage Amendment, says that those marriages, for purposes of all Wisconsin law, do not exist. That means intestacy, that means fishing licenses, that means workers' comp, that means a whole range of benefits and protections and obligations, by the way, that those marriages don't get. And in addition, my colleague said that...
What do you mean by workers' comp? I don't get.
Questions about workers' comp benefits for spouses. For spouses, spousal benefits under programs. So there are many, many programs under state law and some under federal law where spouses get benefits.
You don't get any of that by virtue of having a domestic partnership?
Your Honor, there is a small list of protections that people can get through the domestic partnership registry. It is nothing like the range of benefits that the state gives to married couples. And crucially, the status and the name of marriage is something that is enormously important to the plaintiffs and to the state, obviously, because they're fighting so hard about this issue. But on that, there's also, in terms of the harms to out-of-state married couples, my colleague said that they can get the federal benefits because they're married in another state. And it's true for some. But there are still a range of crucial federal benefits that aren't available to people who live in Wisconsin, even if they're married in Minnesota or another state. For example, Family Medical Leave Act doesn't cover them because the federal statute says looks to whether they are married under Wisconsin law, the place of where they live. Some veterans' benefits also are limited based on whether the state that you live in recognizes your marriage as opposed to the state that you got married in. And finally, Social Security survivor benefits also are limited based on whether the state that you live in recognizes that. So there are federal benefits that are very important and a whole range of state benefits that are denied to both the people seeking recognition of their out-of-state marriages and, of course, to the people who live in Wisconsin, haven't married elsewhere because they want to get married at home. I'd like to talk again about, Your Honor, I'd talk about Windsor. The Supreme Court's decision in Windsor, we suggest, reinforces the idea that the court should strike down Wisconsin's marriage amendment. There are striking similarities between the Defense of Marriage Act on the one hand and Wisconsin's state constitutional amendment barring marriage and the recognition of marriage. Both measures facially target same-sex couples. Both measures are intended to exclude same-sex couples from marriage or from the recognition of their marriages.
Right, but the Supreme Court told us as clearly as one could hope for that Windsor is limited. That it doesn't decide this question.
Indeed, Your Honor, it doesn't decide. The holding in Windsor does not decide this question. That's absolutely correct. But
and the majority opinion disclaims any effect on this question.
Well, I think the majority decision says this holding is limited to these existing marriages, and that is correct. But, Your Honor, the principles announced in Windsor apply obviously to other cases and apply to this case. And the similarity between the Defense of Marriage Act, the purpose behind the Defense of Marriage Act is enormously similar to the admitted and conceded purpose of the...
Of course, the Supreme Court emphasized a lot of rather ugly legislative history about the Defense of Marriage Act. Do you have any of that type of material? See, I'm curious about this reenactment in 1997. Is there anything? Do we know anything about why they did it? Your opponent said, well, it was to prevent the Wisconsin homosexuals from going to Hawaii, getting married, and coming back.
And, Your Honor, in Wisconsin, the legislature in two successive sessions passed a resolution that put a constitutional amendment on the ballot in 2006 and was voted on by the people. The legislative history of that amendment is quite clear that the purpose was to ensure that same-sex couples could not marry and that any marriage-light kind of system couldn't be created by the legislature.
I thought we'd been told that there really isn't much in the record along those lines.
Well, Your Honor, what is in the record, what is in the record is a clear intent to draw a line here that says that different sex couples on one side of the line and same-sex couples are on the other.
That's evident from the language of the provisions.
Indeed.
Are you trying to draw on legislative history of any kind or the ratification history?
Well, Your Honor, there is evidence in the record about the legislative memos that put the measure on the ballot. There is evidence in the record about some of the ballot materials and other materials that were circulated to the public about what the measure was about, and they do show very clearly an intent to treat same-sex couples differently. But look, I think that the similarities again.
Do they give reasons, or are they just fearful of the future, like Mr. Samuels said?
A bunch of it, Your Honor, is fear. A bunch of it is saying specifically, we need to protect ourselves from activist judges. We need to protect ourselves from Massachusetts or from Hawaii. And the point here, Your Honor, is that we don't need to show any kind of hostility by the legislature or by the populace in order to make out a constitutional violation here. All we have to do is show that there is, at a minimum, no rational basis for this law, which we think we have shown in spades. And we also can show, we think, that there are various reasons for the court to apply some level of heightened scrutiny here. The fundamental right to marry is one of them. Sexual orientation classifications, we submit, is one of them, because sexual orientation classifications should be considered to trigger heightened scrutiny under the Equal Protection Clause, because presuming that government discrimination based on sexual orientation is constitutional is not something that this court should do. It's something that demeans the equal dignity that the court in Windsor said was so important. And also, as an
example of how unhelpful the concept of heightened scrutiny is, if you were dealing with pedophiles, you wouldn't say they were any regulation of pedophiles was subject to heightened scrutiny because it's an innate sexual orientation.
No, I wouldn't,
history
Your Honor.
Of discrimination.
Right.
No, I wouldn't, Your Honor. But clearly, even if heightened scrutiny applied there, the state would have a very compelling interest.
Yeah, but I mean, we don't think in those terms, right?
Well, Your Honor, the Second Circuit, as recently as 2012 in the Windsor case, did think in those terms and said that heightened scrutiny should apply.
No, I mean, we don't think of those terms when we're dealing with all sorts of sexual compulsions, right? We just say this is obviously very harmful to other people, so it's illegal, even though that these people can't help it in many cases.
Yes, but Your Honor, in this context, when we're talking about lesbians and gay men, there's nothing criminal about it. There's nothing.
No, I understand. I'm just questioning the utility of heightened scrutiny.
The other basis for heightened scrutiny here, Your Honor, is what Judge Hamilton raised, which is the fact that these statutes and constitutional amendments have facial sex classifications in them.
They have what?
A sex classification, Your Honor. Men can marry women, but men cannot marry men. That is.
Statute books are filled with sexual classification.
Yes, Your Honor, and I think the court in VMI says that every sex classification triggers heightened scrutiny, and it may survive that scrutiny and it may not, but that is a basis for this court to apply.
What, separate men's and women's bathrooms?
And, you know, the state would offer interests that would that might well justify that.
You really think you have to get into that? I don't get it. I
think the Supreme Court in VMI has said that sex classifications trigger heightened scrutiny, and I think there's good reason for that, Your Honor. Going back to Windsor, Your Honor, I think Windsor applied a careful consideration analysis. I think careful consideration is something that this court should apply here as well. And what I'd point the court to is the Romer decision. Romer also talked about careful consideration. And what prompted careful consideration there was the imposition by Amendment 2 in Colorado, which was an amendment to the state constitution that said that gay people couldn't get any civil rights protections. And the court
Couldn't get what?
any civil rights protections.
Yeah,
Your Honor.
Romer and Windsor both involve actions, though, that took away rights that had been granted, right? I don't know how much, we really don't have that here.
Well, Your Honor, there's certainly in Romer, what Romer didn't just take away. It is true
It
that
created
Romer,
new barriers to legislation that would protect people from sexual orientation discrimination, correct?
It did, because the state of Colorado didn't at the time have a sexual orientation non-discrimination law, but that amendment prevented it from doing that. And in addition, it took away rights that existed in certain municipalities.
Took away rights, created new obstacles. I mean, gay marriage is a pretty new concept, right?
Well, Your Honor, but this law similarly imposes a broad sweeping disability on a narrow group of people. The narrow group of people...
Well, the disability has existed for the life of the Republic, right?
It is, Your Honor, and we have recently come to a greater understanding of the depth of the deprivation that law imposes on same-sex couples. And as we get to understand that, I think the parallels with Romer become very, very clear. And the court said that where there is an imposition of a broad sweeping disability on a narrow group of people, again, it's the same group here, the broad sweeping disability is, we've talked at length during the course of this argument about the range of different things that marriage touches. Marriage, saying that same-sex couples can't get married, cuts them out of a whole social, legal network of protections and obligations that covers everything from whose name goes on the birth certificate to what status is listed for the decedent when someone dies, and whether a surviving spouse is listed as a surviving spouse or suddenly disappears at the moment of death and with the last official document of that person's life. And in between, medical decision-making and a whole host of other things. To say to same-sex couples that you can't get access to any of that, both the social status that comes with the name and the status of marriage and all of the protections and obligations, is the kind of sweeping disability that the court was concerned about in Romer, and that prompted the court in Romer to apply what it called their careful consideration, and we have learned more from the Supreme Court in Windsor about what careful consideration looks like. And there, the court didn't look at hypothetical justifications for the law. It instead looked at what is the purpose of the law before us and what is the effect of the law. And I submit that the purpose of the law in Wisconsin and in Indiana, the laws have the same purpose as DOMA, and they have the same effect as DOMA. They say to same-sex couples and all the world that their relationships are second class. And they humiliate the children of same-sex couples because they say to them that their families are not the same, not worthy in the same sense as the families of their friends.
Okay. Well, thank you, Mr. Essex.
Thank you very much,
So,
Your Honor.
Mr. Samus, your time has expired, but you can have a couple of minutes if you want.
Thank you, Your Honors. I'll try to be brief. I have 2 points I'd like to make. The first is with respect to the relief entered by the district court. Paragraph 4 of the district court's injunction enjoining Governor Walker and only Governor Walker violates Rule 65 because it did not describe in reasonable detail the acts restrained or required. It's open-ended. It doesn't identify a single statute, and it doesn't tell Governor Walker what he must do or how he should do it.
Well, I should think Governor Walker would welcome that, given maximum flexibility to comply with the order. You really want the district judge or us to micromanage and tell him this is what you should change in all your statutes?
Well, the problem is that Governor Walker is subject to contempt for not...
No, he's subject
What
to
is it?
contempt.
What is it you don't understand?
Paragraph 4 of the district court's injunction enjoins Governor Walker to direct all department and agency heads to treat same-sex couples the same as different sex couples with respect to the rights, to determining the rights, privileges, protections, and obligations of marriage.
So what don't you understand? And
What that
means.
means.
Have you asked the district judge to clarify?
We have not yet, Your Honor.
I just don't get it. It means treat same-sex and opposite-sex couples the same. Don't take into account sexual orientation.
Well, the Wisconsin statutes use different definitions. Some rights incident to marriage are for spouses. some are for husbands and wives, and some yet further are for parents.
Yeah, but
which
isn't
is
the whole point that the governor gets his agency heads to analyze it, analyze the decision, make certain judgments, get input from various entities that would have something to say about what it means, comes up with a scheme, and then if there are problems, it would be challenged. I mean, it's just like any other directive the court gives to a governor or head of an agency.
Well, the first three paragraphs of the district court's injunction identify certain specific tasks: issue marriage licenses, recognize marriage
right, but the
licenses, file
district
them.
court the district court can't anticipate every little thing and look at every little law in Wisconsin to figure out what it should say. I mean, that would truly be, as Judge Posner says, micromanaging.
Well, it doesn't identify even one single statute. It doesn't tell Governor Walker what
why
he must
don't you
do.
why don't you draw up some suggested program of compliance and submit it to the district judge?
Well, ultimately, what it is a policy determination for the legislature, not for the court.
Oh, you're not back to that again.
That's an entirely different problem.
Yeah.
In closing, Your Honors, in 1982, Wisconsin became the first state in the Union to ban discrimination based on sexual orientation in employment, housing, and public accommodations. Governor Lee Dreyfus said about the law, "It's a fundamental tenet that the government ought not intrude in the private lives of individuals where no state purpose is served." It's our position that the same principle that Governor Dreyfus discussed in 1982 applies equally today. And that's the basis for our negative positive rights argument, namely that substantive due process doctrine does not require the state to affirmatively confer the positive right of marriage on plaintiffs. Rather, the substantive due process clause is a vehicle for preserving traditions from unwarranted government interference. Thank you, Your Honors.
Okay, well, thank you very much to you, Mr. Samuelson, and Mr. Essex, and of course to the lawyers in our Baskin case, and the court will take the case under advisement and stand in recess.